A Commonwealth realm is one of 16 sovereign states that are members of the Commonwealth of Nations, have Queen Elizabeth II as the reigning constitutional monarch, and have in common the same royal line of succession. The Statute of Westminster 1931 provided for the then Dominions, named therein as Canada, Australia, New Zealand, the Union of South Africa, the Irish Free State, and Newfoundland, to have full or nearly full legislative independence as equal members of the British Commonwealth of Nations, having with the United Kingdom one person as the sovereign of each respectively. Thereafter, India and Pakistan in 1947 and Ceylon in 1948 became dominions. By the early 1950s, in order to reflect the equality between the countries in that group, each came to be known as a realm. The term was formally used with Britain's proclamation of Elizabeth II as Queen in 1952 and was adopted for the modern royal styles and titles under the legislation enacted by the individual countries. The phrase Commonwealth realm is only an informal description, not an official term. The sovereign status of other Commonwealth realms was later granted directly. Current Commonwealth realms. The number of independent countries in the Commonwealth of Nations that had the same person as monarch reached 18 between 1983 and 1987. There have been 16 realms since 1992. As of 2010 update, they have a combined area of 18.7 million km² and a population of 140 million, of which all but about 2 million live in the six most populous: the United Kingdom, Canada, Australia, Papua New Guinea, New Zealand, and Jamaica. Relationship of the realms. The Commonwealth realms are, for purposes of international relations, sovereign states. They are united only in their voluntary connection with the institution of the monarchy, the succession, and the Queen herself. The person of the sovereign and the crown were said in 1936 to be the most important and vital link between the realms. Political scientist Peter Boyce called this grouping of countries associated in this manner an achievement without parallel in the history of international relations or constitutional law. Terms such as personal union, a form of personal union, and shared monarchy, among others, have all been advanced as definitions since the beginning of the Commonwealth itself, though there has been no agreement on which term is most accurate, or even whether personal union is applicable at all. The United Kingdom no longer holds any legislative power over any country besides itself, although some countries continue to use, by their own volition, the Judicial Committee of the Privy Council as part of their own judiciary, usually as the highest court of appeal. Since each realm has the same person as its monarch, the diplomatic practice of exchanging ambassadors with letters of credence and recall from one head of state to another is redundant. Diplomatic relations between the Commonwealth realms are thus at a cabinet level only, and high commissioners are exchanged between realms. A High Commissioner's full title will thus be High Commissioner for Her Majesty's Government in country. For certain ceremonies, the order of precedence for the realm's High Commissioners or national flags is set according to the chronological order of, first, when the country became a dominion, and then the date on which the country gained independence. Conflicts of interest have arisen from this relationship amongst independent states, ranging from minor diplomatic matters, such as the monarch expressing on the advice of one of her cabinets views that counter those of another of her cabinets, to more serious conflicts regarding matters of armed conflict, wherein the monarch, as head of state of two different realms, may be simultaneously at war and at peace with a third country, or even at war with herself as head of two hostile nations. In such cases, viceroys have tended to avoid placing the sovereign directly in the center of the conflict, meaning that a governor-general may have to take controversial actions entirely on his or her own initiative through the exercise of the reserve powers. In recent years, advocates have argued for free movement of citizens among a subset of the Commonwealth realms. the United Kingdom, Canada, Australia, and New Zealand, which they argue share the same head of state, the same native language, and the same respect for the common law. Opinion on the prospect of the plan coming to fruition is mixed. British Eurosceptics have expressed a preference for a relationship, similar in nature and goals to the EU, between the same four countries. The CANZ-UK Union, though this possibility has also been characterised as difficult and in some ways far-fetched. The Crown in the Commonwealth realms. The evolution of the Commonwealth realms has resulted in the Crown having both a shared and a separate character, with the one individual being equally monarch of each state and acting as such in right of a particular realm as a distinct legal person guided only by the advice of the cabinet of that jurisdiction. This means that in different contexts the term Crown may refer to the extra-national institution associating all 16 countries, or to the Crown in each realm considered separately. However, though the monarchy is therefore no longer an exclusively British institution, having become domesticated in each of the realms, it may in the media and legal fields often still be elaborated as the British Crown for reasons historical, of convenience, or political. Regardless of the different, specific, and official national titles and terms used when addressing the Queen of the citizenry in each jurisdiction. For example, in Barbados the Queen is titled as Elizabeth II, Queen of Barbados, or simply the Queen of Barbados, with her full title making mention of her position as Queen of the other Commonwealth realms. From a cultural standpoint, the sovereign's name and image and other royal symbols unique to each nation are visible in the emblems and insignia of governmental institutions and militia. The Queen's effigy, for example, appears on coins and banknotes in some countries, and an oath of allegiance to the Queen is usually required from politicians, judges, military members and new citizens. By 1959, it was being asserted by Buckingham Palace officials that the Queen was equally at home in all her realms, royal succession and regency to guarantee the continuity of multiple states sharing the same person as monarch of each. The preamble of the Statute of Westminster 1931 laid out her convention that any alteration to the line of succession in any one country must be voluntarily approved by the parliaments of all the realms. This convention was first applied to the abdication of Edward VIII in 1936. For expediency and to avoid embarrassment, the British government had suggested the Dominion governments regard whomever is monarch of the UK to automatically be their monarch. However, the Dominions rejected this. Prime Minister of Canada William Lyon Mackenzie King pointed out that the Statute of Westminster required Canada's request and consent to any legislation passed by the British Parliament before it could become part of Canada's laws and affect the line of succession in Canada. Sir Maurice Squire, first Parliamentary Counsel in the UK, reflected this position, stating the Act of Settlement was a part of the law in each Dominion. Though the Statute of Westminster is today law only in Canada, Australia, and the United Kingdom, the Convention of Approval from the other realms was reasserted by the Perth Agreement of 2011, in which all 16 countries agreed in principle to change the succession rule to absolute primogeniture, remove the restriction on the monarch being married to a Catholic, and lessen the number of members of the royal family requiring the monarch's permission to marry. These changes came into effect on 26 March 2015. Alternatively, a Commonwealth realm may choose to cease being such by making its throne the inheritance of a different royal house or by becoming a republic, actions to which, though they alter the country's royal succession, the convention does not apply. Agreement among the realms does not, however, mean the succession laws cannot diverge. During the abdication crisis in 1936, the United Kingdom passed His Majesty's Declaration of Abdication Act with the approval of the Parliament of Australia and the governments of the remaining dominions. The act affected Edward's abdication in the United Kingdom on the 11th of December, as the Canadian government had requested and consented to the act becoming part of Canadian law, and Australia and New Zealand had then not yet adopted the Statute of Westminster. The abdication took place in those countries on the same day. The Parliament of South Africa, however, passed its own legislation, His Majesty King Edward VIII's Abdication Act, 1937, which backdated the abdication there to the 10th of December. The Irish Free State recognised the King's abdication with the Executive Authority Act 1936 on the 12th of December. According to Antiomy, this demonstrated the divisibility of the Crown in the personal, as well as the political, sense, for E. H. Coghill. Writing as early as 1937, it proved the convention of a common line of succession is not of imperative force, and Kenneth John Scott asserted in 1962 that it ended the convention that statutory uniformity on these subjects would be maintained in the parts of the Commonwealth that continued to owe allegiance to the Crown. Today, some realms govern succession by their own domestic laws, while others, either by written clauses in the Constitution or by convention, stipulate that whomever is monarch of the United Kingdom is automatically also monarch of that realm. It is generally agreed that any unilateral alteration of succession by the UK would not have effect in all the realms. Following the accession of George VI to the throne, the United Kingdom created legislation that would provide for a regency in the event the monarch was not of age or incapacitated. Though input was sought from the Dominions on this matter, all declined to make themselves bound by the British legislation, feeling instead that the Governors-General could carry out royal functions in place of a debilitated or underage sovereign. Some realms that were later created incorporated this principle into their constitutions. New Zealand included in its Constitution Act 1986 a clause specifying that, should a regent be installed in the United Kingdom, that individual will carry out the functions of the monarch of New Zealand. Monic's role in the realms: the monarch holds the highest position in each Commonwealth realm and may perform such functions as issuing executive orders, commanding the military forces, and creating and administering laws. However, each country now operates under the Westminster system of parliamentary democracy and the concept of responsible government, meaning that the monarch exercises her powers only on the advice of her crown ministers, who are usually drawn from, and thus responsible to, the elected chamber of the relevant parliament. In some realms, such as Papua New Guinea, these conventions are codified in constitutional law. The sovereign resides predominantly in her oldest realm, the United Kingdom, and thus carries out her duties there mostly in person. The Queen appoints viceroys to perform most of the royal constitutional and ceremonial duties on her behalf in the other realms. In each, a Governor-General is her personal national representative, as well as a Governor as her representative in each of the Australian states. These appointments are all made on the advice of the Prime Minister of the country or the Premier of the state concerned, though this process may have additional requirements. In certain other cases, the extent to which varies from realm to realm. Specific additional powers are reserved exclusively for the monarch, such as the appointment of extra senators to the Canadian Senate, the creation of honours, or the issuance of letters patent, and on occasions of national importance. The Queen may be advised to perform in person her constitutional duties, such as granting royal assent or issuing a royal proclamation. Otherwise, all royal powers, including the royal prerogative, are carried out on behalf of the sovereign by the relevant viceroy, which, apart from those already mentioned, include a lieutenant governor in each province of Canada. In the United Kingdom, the Queen appoints councillors of state to perform her constitutional duties in her absence. Similarly, the monarch will perform ceremonial duties in the Commonwealth realms to mark historically significant events. He or she does so most frequently in the United Kingdom. In the other countries, during tours at least once every 5 or 6 years. meaning the Queen is present in a number of her dominions outside the UK, or acting on behalf of those realms abroad, approximately every other year. For this work, the sovereign receives no salary from any state, instead, only the expenses incurred for each event are, due to the nature of the crown in the realms, funded by the relevant state individually through the ordinary legislative budgeting process and, if called for, by the organization that invited the sovereign's attendance. These engagements are organized in order for the Crown to honor, encourage, and learn about the achievements or endeavors of individuals, institutions, and enterprises in a variety of areas of the lives of the Queen's subjects. Citizens in Commonwealth realms may request birthday or wedding anniversary messages to be sent from the sovereign. This is available for 100th, 105th, and beyond for birthdays, and 60th, 65th, 70th, and beyond for wedding anniversaries. Religious role of the monarch. The sovereign's religious role differs from country to country. In all realms except Papua New Guinea, the Queen is sovereign, by the grace of God, a phrase that forms a part of her official title within those states. In Canada, the United Kingdom, and New Zealand, defender of the faith. The ancient phrase first granted in 1521 by Pope Leo X to King Henry VIII, is also included as a part of the royal title, and the sovereign is anointed as such in the only coronation that takes place in any of the realms, a ceremony in the context of a church service imbued with theological and constitutional symbolism and meaning, held at Westminster Abbey in London, United Kingdom. However, it is solely in the United Kingdom that the Queen actually plays a role in organised religion. In England, she acts as the supreme governor of the Church of England and appoints its bishops and archbishops who thereafter act as her lords spiritual. In Scotland, she swears an oath to uphold and protect the Church of Scotland and sends to meetings of the Church's General Assembly a Lord High Commissioner as her representative, when she is not personally in attendance. Royal family. As with the sovereign, a single royal family is shared by the Commonwealth realms. Still, it is frequently referred to in a casual fashion as the British royal family, sometimes causing conflict with official national titles, such as in Canada. Though there is no strict legal or formal definition of who is or is not a member of the royal family, the group is loosely defined as the extended family of the monarch, and these persons constitute the apex of a modern royal court. These persons, either as representatives of the monarch or as part of their own charitable endeavors, regularly perform public duties at hundreds of events throughout the 16 realms each year, funded in the same way as the monarch's similar execution of his or her ceremonial role. Their work, which is all formally recorded in the court's circular, draws public attention to amicable relations within and between the nations of the Commonwealth and beyond. The members of the royal family draw enormous media coverage in the form of photographic, written, and televised commentary on not only their activities and public roles, but also family relationships, rites of passage, personalities, attire, and behavior. Flags. The Queen employs various royal standards to mark her presence, the particular one used depending on which realm she is in or acting on behalf of at the time. There are currently unique flags for Australia, Barbados, Canada, Jamaica, New Zealand, and two variations for the United Kingdom, one for Scotland and another for the rest of the country. All are heraldic banners displaying the shield of the sovereign's coat of arms for that state, and each, save for those of the UK, are defaced in the centre with the Queen's personal flag, a crowned E for Elizabeth surrounded by a garland of roses representing the countries of the Commonwealth. This latter flag on its own is used for realms that do not have a unique personal standard for the monarch, as well as for general use in representing the Queen as head of the Commonwealth. The monarch previously held royal standards for Sierra Leone, Mauritius, Malta, and Trinidad and Tobago, but these banners became obsolete where the countries became republics. Other members of the royal family have their own personal standards. In the United Kingdom, most have their own distinctive banner or banners. The Prince of Wales, Duke of Cambridge, Princess Royal, Duke of York, and Earl of Wessex also have one each for Canada. Those who do not possess a standard for an individual realm will use their British standard to identify themselves when touring other Commonwealth realms and foreign countries. The Governors-General throughout the Commonwealth realms also each use a personal flag, which, like that of the sovereign, passes to each successive occupant of the office. Most feature a lion passed on to top a street. Edward's royal crown with the name of the country across a scroll underneath, all on a blue background. The two exceptions are those of, since 1981, Canada and, since 2008, New Zealand. The lieutenant governors of the Canadian provinces each have their own personal standards, as do the governors of the Australian states.